Welcome back. Our today's topic is international law in international relations. Lecture outlines introduction, definition, sources of international law, significance, challenges, types of international law, examples, and lastly, conclusion. So let's start our today's lecture from introduction. Introduction to international law. International law is a set of rules, agreements, and treaties that are bound between countries. It governs the relations and conduct of states, international organizations, and in some cases, individuals. The primary purpose of international law is to ensure peace, coexistence, promote justice, and facilitate cooperation among nations. So, now we have definition of international law, a body of rules and principles of action that are binding upon states and other international actors in their relation with one another. It encompasses broad range of subjects including human rights, environmental protection, international trade, and the conduct of war. Challenges in international law enforcement. One of the most significant challenge is the lack of centralized enforcement mechanism. Unlike domestic law, which has courts and policies to ensure compliance, international law relies on the willingness of states to abide by the rules. Sovereignty. States are reluctant to relinquish their sovereignty, which can hinder the implementation and effectiveness of international law. Nations may resist external their domestic affairs. Geopolitical tensions. Conflict between powerful nations can undermine international law. For example, geopolitical interest can lead to selective enforcement or violations of international agreements. Diverse legal system. The coexistence of various legal traditions and systems can create complexities in application and interpretation of international law. Criticism of international law. This is an inequality that critics argue that international law often reflects the interest of powerful states, leading to unequal treatment of small and less powerful nations, which is very true. Ineffectiveness. Some believe that international law is ineffective in addressing global issues due to the reliance on state consent and the absence of robust enforcement mechanism. Ambiguity. The vigilance and complexity of international legal norms can result in inconsistent application and interpretation, leading to disputes and confusion. Slow adaptation. International law can be slow to adapt to emerging global challenges such as cyber threats, climate change, and new forms of warfare. Types of international law. So here we have few types of international law. Public international law. Public international law governs the relationship between sovereign states and international organizations. It encompasses a wide range of issues including treaties and conventions, legally binding agreement between states such as Geneva Conventions, which set the standards for humanitarian treatment during war. Customary international law. Practices that have been constantly followed by states out of a sense of legal obligations. An example is the principle of non-refoulement, which prohibits returning refugees to a country where they face various threats. International organizations. Institutions like the United Nations that facilitate cooperation and governance on global issues. Private international law, also known as conflict of laws. Private international law deals with disputes between private individuals or entities that cross international borders. It addresses issues like jurisdiction, determine which court has the authority to hear a case, choice of law, deciding which country's law apply to a given dispute, recognition and enforcement of foreign judgment, determining whether a judgment from one country will be recognized and enforced in another. International. Thirdly, we have international humanitarian law. International humanitarian law, also known as the law of armed conflict, regulates the conduct of armed conflict to minimize suffering. It includes Geneva Convention and additional protocols. Key treaties that protect wounded soldiers, prisoners of war, and civilians during armed conflict. Huge conventions, treaties that govern the means and method of warfare, including the prohibition of certain weapons and tactics. Fourth, international human rights law. This body of law focuses on protecting the fundamental rights and freedoms of individuals. Key components include Universal Declaration of Human Rights, a foundational document that outlines basic human rights principles, international conventions on civil and political rights, and economic, social, and cultural rights, binding treaties that expand on the UDHR's principle and set specific legal obligation for the states. Fifth one, international criminal law. International criminal law address crimes of international concern such as genocide, act committed with the intent to destroy a national, ethnic, racial, or religious group. War crimes violations of the laws and customs of war, such as targeting civilians or using prohibited weapons. Crime against humanity, widespread or systematic attack against civilians, including murder, enslavement, and torture. The International Criminal Court, an independent judicial institution, prosecute individual for serious international crimes. National environmental law. This body of law deals with the protection of global environment and regulation of activities that impact it, including multilateral environmental agreement, treaties that address specific environmental issues such as Paris Agreement on climate change principle and customary norms, guidelines for suitable development and environmental protection such as polluter pays principle. International economic law. International economic law governs economic relation between states and states, includes trade law, rule and agreement that regulate international laws such as those established by the World Trade Organization, investment law treaties and agreements that protect foreign investment such as bilateral investment treaties. Financial law, regulations that govern international financial transactions and institutions such as the International Monetary Fund and the World Bank. Sources of international law, treaties and conventions. Treaties and conventions are formal agreements between states that create binding legal obligation. They are primary source of international law and can cover a wide range of issues from human rights to trade or regulation. Examples include Geneva Convention regulating humanitarian treatment in armed conflicts, the Paris Agreement addressing climate change mitigation and adaptation. Customary international law consists of practices that states follow out of sense of legal obligations. These practices become legally binding over time through constant and widespread state practice. Examples include the principle of non-involvement, immunity of diplomatic panel. Real world examples. So here we have some real world example. The Geneva Convention establishing human rights standards during armed conflicts. The United Nations Convention on International Law of Sea regulates maritime activities. The International Criminal Court prosecutes individuals for international crime. So, importance of international law. Framework for cooperation. International law provides a structured framework for cooperation between states. It helps manage and resolve conflicts, facilitate trade, and promotes legal peace and security. Legitimacy and reputation. Adhering to international law enhance a state's legitimacy and reputation on a global stage. States that follow international norms are often seen as reliable and trustworthy partners. Mutual benefits. Many international laws are created because they offer mutual benefits. For example, law governing trade, environmental protection, and human rights can lead to better outcome for all principal states, for all participating states. Predictability and stability. International law contributes to predictability and stability in international relations. It sets clear rules and expectations, reducing the likelihood of arbitrary actions. Moral and ethical standards. International law often reflects shared moral and ethical standards. States create or adhere to these laws to promote values such as justice, human rights, and humanitarian principles. 6.1. Pressure and influence. State may also create and follow international law due to pressure from other states, international organization, or public opinion. Compliance by a way to avoid confusion. Why states create international law, which is a very important question. Sovereignty and control. States wants to maintain their sovereignty and control over their own affairs. By being selective about which law they accept, they can ensure that their national interests and policies are not unduly compromised. Strategic interest is states often evaluate international laws based on their strategic interests. They are more likely to accept laws that align with their economic, political, and security goals. Domestic politics. The acceptance of international laws can be influenced by domestic politics consideration. Governments may force pressure from domestic interest groups, political parties, or public opinion to accept or reject certain laws. Reciprocity and mutual benefit. States are more inclined to accept international law that offer reciprocal benefits. If they see that other states are also adhering to these laws, they are more likely to comply. Legal and ethical standards. States may accept international law that reflect their own legal and ethical standards. This alignment can make it easier to integrate international law into their domestic legal system. 6. International reputation. Adhering to certain international law can enhance a state's reputation and standing in the international community. States may be selective, ensure they are seen as responsible and cooperative actors. Enforcement and compliance. States may be particular about international laws based on their enforceability and the mechanism for compliance. They are more likely to accept laws that have clear enforcement mechanisms and are backed by international institutions. So lastly we have conclusion. While international laws plays a crucial role in maintaining global order and promoting cooperation among states, it faces significant challenges and criticism. Addressing these issues Addressing these issues is essential for enhancing the effectiveness and fairness of the international legal system. By working together, the international community can strive towards a more just and equitable world. So, this is all about our today's topic. I hope you understand today's lecture. See you in the next lecture. Thanks for watching.